and the court's ahead of me, but reciprocity. Lansing can come, the state health code is divided into state and local. Lansing, the director in Lansing at the state level can come to the local health department and exercise the local health law. That's right in the statute.
So your interpretation of that under 2437, I'm sure is the statute you're talking about.
Yeah.
There's no citation that I can find to that statute anywhere in the cases that mention it directly. But the language says that the health department, the Michigan Department of Health and Human Services can exercise any power vested in the local health department or in an area where the local health department does not meet the requirements of this department. What does that mean?
Good question. That's the difficulty of that. And I don't know what that means.
What's your interpretation?
That the local health department could argue that the area of the epidemic that they have flagged is statewide, and so they don't want to exercise the power, and they prefer that the state government do it.
Well, when it says this part, shouldn't that be or wouldn't that be referring to 2437?
2437 doesn't have any emergency powers associated with it,
Right.
So it would be a dead-end statute then.
So you view 2437 as enabling the State Department of Michigan, the Michigan Department of Health and Human Services, to use any of the other statutes that still survive.
Correct.
24, 53, 51, any of them if they so choose.
Yes, and vice versa. The local health department can use the state law.
Is there any published or unpublished authority that you found from an appellate court that supports that interpretation?
No, it's never been challenged.
Right, I couldn't find it. And I was interested whether or not you found it.
I haven't seen anything like that, and we don't know the coordination between the state and local, but we know that the local acted. And actually, there is a connection. When the Iron Pig case began, they brought in a local health order, and they cited 2453 and 2451. Then the state came in and cited their portion of the statute, so they were piggybacking, if you will, on the local health department. So they both worked in concert. The local health department and then the state liquor license and MDAR on the food license all worked together under the state health code to close indoor dining and have mask mandates and regulations and things like that. So it was very circular, ultimately, in this case. And so either one, we could have brought in the local health department, but we took an appeal from the state health department, and that really wasn't on my radar, Judge, until a year after you ruled, when the Court of Appeals in Ottawa in the published case said, right on point, the local statute allows the health officer, and by then, totally a year after you ruled, allows the local health department to come in and issue orders, and the Board of Commissioners, the elected board, can do nothing. And that's still the law. So the T&B case comes out, Judge, and this would have been in June of 2023. Iron Pig was actually on the same track as the T&B case, but the health department and the Attorney General rescinded their appeal. They abandoned it, and the case closed, putting their hat on T&B. Well, in my view, Judge, T&B, a published case, is a mirror of this court's ruling. A year and a half after you ruled, T&B comes out and says 2253, the state version, is unconstitutional because it's a violation of the non-delegation doctrine. And in my view, Judge, they incorporated and were well aware of your ruling and have read it. They also said that the epidemic is undefined. And they went further than you did, because you talked about obesity and opioid and tobacco. They said loneliness could be an epidemic. And if people are lonely, then the state health department can start to take some action. And the local health department, because these laws are the same at the state and the local level. But most importantly, T&B addressed mootness and said, so long as the health department disputes the constitutionality of the statute, it's not moot. It's an actual controversy. And they do. They're here. I believe they're going to stand up here and say, we have this power, and we want to exercise it. And we may or may not.